Well, folks, it's the State of Wisconsin Circuit Court, Manitowoc County, State of Wisconsin plaintiff versus Stephen Avery. Response opposing a motion for post-conviction and evidentiary hearing relief under Wisconsin Statute 97106. State of Wisconsin, by undersigned counsel, opposes defendant Stephen A. Avery's motion for post-conviction relief and request for an evidentiary hearing pursuant to Wisconsin Statute 97406. He claims that his newly discovered purported witness, Thomas Sawinski, testimony would have allowed him to meet the third-party Denny test to introduce third-party perpetrator evidence as trial and allege that Bobby Dassey, Avery's nephew, committed the murder and then planted all the evidence to frame Avery. He also claims that the state committed a violation of Brady versus Maryland by failing to turn over to the defense counsel a snippet of audio recorded by Manitowoc County Sheriff's Office when Sawinski called them on November 6, 2005, which Avery claims would have led defense counsel to Sawinski and allowed them to present the theory of defense instead of the one they chose. He also attempts to reiterate that Brady claim regarding Kevin Ramlow's assertion that he told Sergeant Colborn on November 4th that he saw a car that looked like the victims parked on the side of the road. Finally, he asked this court to order a new trial in search of justice. The motion is insufficiently pled, unsupported by sufficient facts, and the record conclusively demonstrates that Avery is due no relief on either his newly discovered evidence or his Brady claims, and the circuit courts have no authority to order a new trial in search of justice unless the request is raised on direct appeal. Accordingly, no evidentiary hearing is necessary, and the court should summarily deny the motion. Background: Teresa Hallbach, a 25-year-old professional photographer, disappeared on October 31st, 2005. She was last seen walking towards Stephen Avery's trailer after photographing a van on the Avery salvage yard. Per Avery's request, she was reported missing on November 3rd, and the RAV4 was found on the Avery property on November 5th. Police searched the Avery property and found burned bone fragments from nearly every bone in the human skeleton in Avery's burnt. That's a lie right there. Avery's burn pit with DNA matching Miss Hallbach's and 2 skull fragments with bullet holes in them, along with the rivets from a type of jeans she owned. Avery's and the victim's blood in the RAV4. The burn remains of the Miss Hallbach's camera and other items. Miss Hallbach's RAV4 key in Avery's bedroom with Avery's DNA on it. Avery's DNA on the hood latch of the RAV4. And the shell casings and bullet fragments in Avery's garage that were fired from the gun in Avery's bedroom, and one of which had Miss Hallbach's DNA on it. A 5-week trial commenced where the state's theory was that the Avery shot Miss Hallbach in the head in his garage and then threw her into the cargo area of the RAV4. He then burned the electronics and camera and cremated Miss Hallbach's remains, transferred some of them to a burn barrel, and they hid the RAV4 until he could crush it in the Avery car crusher. Avery's theory of defense was that the police were biased against him because of a wrongful conviction lawsuit he had pending against Manitowoc County and the Sheriff's Department and planted the evidence against him. The jury found Avery guilty of first-degree intentional homicide and felon in possession of a firearm. He was sentenced to life without possibility of extended supervision. Avery appealed. The conviction was affirmed. Avery filed the Wisconsin Statute 97406 in motion pro se in 2013. The motion was denied and a subsequent appeal was stayed and later dismissed on Avery's motion. Avery then, between 2017 and 2019, filed an additional 6 post-conviction motions alleging myriad claims of error, all of which were denied. Every appeal to the Court of Appeals was affirmed. The Wisconsin Supreme Court denied his petition review on November 17, 2021. Avery then filed the motion at issue here seeking an evidentiary hearing. He claims that the state committed a Brady violation by failing to provide his defense counsel with a snippet of audio recorded by the Manitowoc County Sheriff's Office on November 6, 2005. When Thomas Sawinski, who used to deliver newspapers to the Avery property, called to report that he needed to speak to someone about the investigation into the Hallbach's disappearance, he also alleges that Sawinski claims he saw Bobby Dassey and an unidentified older male pushing a dark blue RAV4 down the road sometime time after Ms. Halbach's disappearance, which Avery alleges is newly discovered evidence warranting a new trial because it would allow him to set forth a third-party preparative defense. Finally, he additionally seeks a new trial in the interest of justice. Argument. The Circuit Court may deny a post-conviction motion without hearing if the facts alleged do not entitle the movement to relief, if one or more key factual allegations in the motion are conclusory. So, sufficiently plead a post-conviction motion, the defendant must present within the four corners of the document the who, what, where, when, why, and how. That would entitle him to the relief he seeks. Mere speculation presented as fact is conclusory allegation insufficient to meet the standard. Sufficiently plead the motion, however, is not enough to require a hearing. The Wisconsin Supreme Court has recently underscored that an evidentiary hearing is not mandatory if he recorded as whole conclusively demonstrates that the defendant is not entitled to relief, even if the motion alleges sufficient non-conclusory facts. Avery failed to plead sufficient facts to meet any of the... This is the state of Wisconsin Attorney General asking to... They asked to be able to respond to Zellner's motion before the Circuit Court makes their decision. So they're just asking them to deny it. But yeah, Avery failed to plead sufficient facts to meet any of the prongs in the Denny test. When a defendant seeks to present evidence that a third party committed the crime for which the defendant is being tried, the defendant must show a legitimate tendency that the third party committed the crime. In other words, the third party had motive, opportunity, and direct connection to the crime. Defendant's offer of proof on these three prongs is insufficient and merely established. Establishes a bare possibility that the third party could have been perpetrator. It is the defendant's responsibility to show a legitimate tendency that the alleged third-party perpetrator committed the crime, where their Sawinski's testimony and the other allegations Avery presented actually allow him to meet the prongs and deny the threshold of the question. If it does not, Avery cannot meet this burden either. Dude, but it should be a problem that even Kathleen Zellner FOIA'd for this information and they told them that it did not exist. I'm referring to all of the phone calls from Manitowoc County. Whether Sawinski's testimony and the other allegations Avery presents actually allow him to meet the prongs of the threshold question. If it does not, Avery cannot meet his burden on either his newly discovered evidence claim or his Brady claim, and it's explained below. Avery has not pledged sufficient facts to meet the Denny test, and thus no hearing is necessary on these new claims. Motive refers to a person's reason for doing something. Stephen Avery had no reason to do anything in the first place. Avery claims that he has established that Bobby Dassey had a motive to kill the victim because pornography and some gory images were found on the communal computer in the Dassey home. But what Avery presents is, on the whole, a misinterpretation of the facts, and that those assertions that are minimally consistent with the record consist of tenuous conjecture only. He falls far short of presenting. Do they realize that these computer stuff was not even... okay, I'm just going to read this. Because it's tenuous conjecture only. He falls for sort of presenting facts that would establish that Bobby Dassey is the person who accessed pornography and other images, let alone that anything found in the Dassey computer plausibly established that Bobby or anyone else had a motive for Ms. Halbach's murder. The facts of the record show that, there was a... I'm going to continue. Computer searches neither revealed to no probative established that anyone, but particularly not that Bobby, had a motive for the murder October 25, 2005. First, Avery has once failed to supply sufficient facts to prove that Bobby conducted any of these searches. As the Court of Appeals noted previously in this case, the mere fact that Bobby could have been at home when some of these searches were conducted fails to establish anything about who actually conducted them. And Avery cannot rely on his computer experts for anyone else's speculation on what Bobby's schedule might have been on those days. Oh, are you kidding me? But speculation based on the timestamps from a fraction of the searches, and once again, all Avery has provided with no citations to any actual facts or record about Bobby's whereabouts at the times, nor to anyone else's who may have access to the home. As the Court of Appeals previously observed, the existence of the searches is not a fact that would establish Bobby as even in the house at those times, let alone that he was the person using the computer or accessing these images. Furthermore, Avery has failed to support all allegations sufficient factual, particularly establish anything related to Bobby Dassey or even to a crime. There are no timestamps given for the searches Avery points to in Veely's report, and an explanation of how any of them are relevant to any individual's motive for the murder. And in generic and mundane, the mere fact that someone searched for news, bloody journal. What about the fact that there is 3 file folders with one DNA, one Teresa Halbach, one Stephen Avery? Yeah. Additionally, Avery's own submitted exhibits show that the bulk of the searches of pornography or gory material that he relies upon for this allegation and motive of similarity to the crime either occurred on a weekend when anyone there could have access to the computer or occurred after 3:45 p.m. on a weekday when Blaine really also had access to it. Nor did Avery account for the fact that Mississauga School District had spring break from March 24th, 2005 to March 30th, 2005. Meaning Blaine and Brendan and anyone that invited over could have been in the home on the weekdays during the time on April 7, 2006. April 18, 2006, meaning Blaine at least also had access during those weekdays. Indeed, the 128 searches listed, only the 20 of them occurred between 7 a.m. and 3:45 p.m. on a weekday, and any of those 28 searches, only 3 of them occurred before Ms. Halbach's murder, 2 at 8:14 a.m. Tuesday, September 13th, and 1 on 7:54 a.m. on Thursday, September 15, 2005. Avery fails to explain how Bobby Dassey's only possibility of having searched for pornography a mere 3 times before Ms. Halbach's murder is sufficient to show that he was rigorous and violent pornography consumer on October 31st, 2005. Who was thus motivated? But the computer searches were happening. Okay, I'm just going to read this. Avery once again attempts to rest the theory on Dressler and McCarthy as if they held that any of the pornography consumption established a motive for the murder regardless of the circumstances. Held no such thing as does not remotely on point, not to mention that a federal habeas corpus case is not binding law in Wisconsin. The fact of the underlying Wisconsin case and the rest are a vast departure from the facts of the case. There, the male victim was last seen approaching Dressler's house for a particular political campaign activity and was assaulted and murdered in an extremely specific and particularly brutal way that included binding, mutilation, and dismemberment. The police found myriad weapons and restraints along with pictures, magazine, videos depicting similarly murdered, mutilated victims, homosexual pornography in Dressler's home. These items were admitted as other evidence from Dressler's intent, motive, and plan to assault to kill the victim in a particular manner. But in that case, there was no dispute that the materials were Dressler's, unlike in this case where then anyone could have been responsible for these searches, and Avery has not provided any facts showing otherwise. The materials found in Dressler's home depicted things that were very closely mirrored to the brutal crime, whereas here in the searches, Avery is attempting to rely on very widely from obscene to mundane with relation to how Ms. Halbach's murder occurred. Indeed, Avery fails to point to a single image or search of someone who was shot and body burned, nor anything would suggest that the widely varying types of pornography and any other similarity whatsoever with Ms. Halbach's murder. And that included such irrelevant or off-point searches as MySpace, tires, race car accidents, Ford Focus accident, deceased girls, and big women naked. In Dressler, there was no dispute that Dressler owned all of the pornography and violent material before the murder occurred, and they were deemed relevant to the show that he was both homosexual and had fascination with mutilation and dismemberment, and thus a motive, intent, and plan to act out his violent sexual fantasies in a particular manner. By the time the male victim arrived at Dressler's home, here the vast majority of material on which Avery relies on actually provides some timestamp for his no similarity or even relation to the Ms. Halbach's murder occurred, and that is not searched for until months after the murder. Avery fails to explain how motive to fulfill a violent porn-fueled sexual fantasy can be formed or proven by someone not viewing any of the material until months after the murder allegedly occurred. To the extent that justice is relevant to law, it actually shows that Avery has not met his pleading burden because the comparison to the shows in which the computer contents would not establish admissible as other acts of evidence to prove motive of Bobby were the defendant. The acts of evidence admissible to meet the familiar three-part test from State Sullivan, requiring it to be ordered the permissible relevance and probative value of the evidence is not outweighed by unfair prejudice. The latter two prongs are not met. Motive is permissible purpose for introducing other acts of evidence, i.e., but in explain, none of what Avery has presented is relevant to show motive to commit this specific crime. The Court of Appeals already determined that Avery's contention that these images are similar to the violent murder of Miss Halbach was false. Pornography and videos of the murder and mutilation deemed relevant, and the rest were undisputedly closely mirrored what happened to the victim in the case and were collected by defendant long before the murder occurred. Nothing about an unidentified person searching the communal computer for various types of pornography and pictures of race car accidents or drowning victims months after Miss Halbach's murder occurred shows an interest in anything similar to the crime, nor makes it any more or less likely that Bobby Dassey had a motive to shoot and kill Miss Halbach on October 20, 2005. The computer contents are simply not relevant. These searches or images also would be excluded because without some closer tie to the events, October 31st, 2005, the prejudicial value would greatly outweigh whatever minimal relevance they might have and influence the jury to convict because they believe whomever conducted the distasteful searches must be a bad person. Yeah? Finally, apart from the lack of evidentiary support, Avery's theory that this pornography accessed months later in 2006 shows that Bobby Dassey had a motive to murder a stranger within minutes of meeting her in October 2005 ignores basic human experience. Despite Avery's admissible police procedure expert's opinion, it's a surprise to find the pornography and gore accessed on a communal computer available to at least 14 of the boys, not to mention anyone else permitted in the Dassey home. But viewing pornography or searching for race car accidents does not create the motive murderer. Even if Avery could have shown that Bobby was the one who performed the searches or accessed these images, which again he has provided no facts to support, provides nothing establishing viewing that these images could have summoned the motive for the murder, and certainly nothing established that Bobby Dassey specifically had such a motive in October 2005. Avery did not plead sufficient facts to establish Bobby's motive. Opportunity. The second prong for the legitimate tendency test asks whether the alleged third-party perpetrator could have committed the crime in question. Evaluation of the prong is guided by the defense theory of the third party's involvement in the crime. Sometimes opportunity can be established by simply showing the third party was the crime scene. Whereas here, the theory of how the third party committed the crime requires that the person to have carried out a series of complicated and difficult tasks. It's not enough to show that the third party's mere presence at the scene are unaccounted for a period of time. In this situation, to meet the opportunity prong, the defendant has to offer evidence that the alleged third-party perpetrator had the skills, contacts, tools, time, and or other means necessary to have committed the crime and staged the scene in the manner for the defendant alleges. In other words, evidence that the third party had the realistic ability to engineer such a scenario, holding the third party's possibility to access the hair and blood samples from the victim, were conjectured insufficient to establish opportunity to frame the defendant. Avery's submissions did not meet this threshold. Avery failed to acknowledge that the defense theory has changed drastically from the time of trial. Then his contention was that he was framed by law enforcement who had plenty of time, knowledge, and access to evidence to plausibly doctor the crime scene. Now he claims that his nephew Bobby Dassey framed him, and he did so in a very short time period. That means that no sufficiently pled to this motion. He had to provide more than just showing that Bobby physically had access to evidence because he was on the property. He had to show that Bobby had the actual ability to both commit the murder and then complete each step of the framing process, and to do so before November 5th, and Avery had to provide facts that was established at least 4 key components necessary to sufficiently plead that Bobby had opportunity to kill the victim, plant all the evidence against his uncle. Then why, then when, the where, and the how. Assuming for the sake of the argument that Avery had pled facts that would establish Bobby's motive to kill in the first place, as explained above, he is not. Avery has not offered anything that would suggest why Bobby would want to frame Avery, especially given the grave risks and extreme difficulty of doing so. Anyone who murders someone typically wants to escape detection, but that does not explain why Bobby would frame Avery for it. Especially doing so would ensure that the law enforcement would be taking a close and intense look at the entire Avery property and everyone who lived on it. He offers no reason why Bobby would want to send him to prison if Bobby Dassey truly wanted to hide the evidence of a crime he committed. There were limitless ways to do so that would not have led to the law enforcement directly to the Dassey's door. Lake Michigan, for example, was a mere few miles from the Avery property, and the property was surrounded by vast tracts of unknown land. Nor has Avery explained why someone who wanted to frame him would go to such length to hide the evidence. Surely if Bobby or anyone else wanted to frame Avery, they wouldn't have gone out of their way to make all the evidence difficult for law enforcement to detect, gather, and connect Avery to. Make it no sense to burn the victim's remains and personal property in an attempt to conceal them, or drip Avery's blood around the RAV4, but then remove the license plate from the attempt to hide the vehicle by covering it up with debris as a point far away from Avery's trailer. Avery has provided no facts explaining why Bobby Dassey is framing him is plausible when he has given no reason whatsoever would explain why Bobby would do this. Avery's argument fails to the when and the how, as well as he's provided nothing that could possibly establish that Bobby had the knowledge, skills, tools, or time to engineer this elaborate ruse. Mere the fact that Bobby was on the Avery property at some time when Avery's hand was bleeding falls far short of the facts necessary to establish that Bobby had the opportunity to successfully orchestrate this extremely complicated supposed frame-up. Mere presence of the scene of the shooting was insufficient to show that the defendant had the contacts or resources necessary to have had opportunity to orchestrate a hit on the victim. The complete absence of the necessary facts to support several crucial elements of how Bobby could have accomplished staging the scene demonstrated that Avery had failed to plead sufficient facts to show that Bobby had an opportunity to kill the victim and frame Avery in the manner. Avery has offered no facts to others to establish how Bobby, an 18-year-old high school graduate with no criminal record whatsoever, who was working the third shift at his furniture factory, managed to steal at some unidentified time prior to October 31st the rifle hanging above Avery's bed with which the victim was shot, and at some other unidentified time before November 5th managed to replace it, with Avery never noticing. Could have... y'all believe this shit? 2. Could have abducted and killed the victim and hidden both her body and her car in some unknown area in the minutes between her arrival on the property and Scott Hatch passing Bobby Dassey around 3 p.m. Facts to establish for killing. I'm going to say this now. I believe that Scott Tadic's alibi of Bobby Dassey was only created to remove Michael Osmundson from the situation completely. But I'll move on. Happened on script and RAV4. Bobby could have hidden the RAV4 and victim's remains in a short period of time, had the scientific sophistication and knowledgeable necessary for it to occur to Bobby to collect, transport, plant Avery's blood from the sink, and as Avery has completely overlooked, his non-blood touch DNA on the hood latch of the victim's RAV4, their keys, and now Bobby acquired his skills to do so successfully. I had a convenient stash of unidentified instruments capable of collecting and transporting liquid blood on hand, with those might be bin, planted the keys in the RAV4 in Avery's trailer unnoticed, and at some unspecified time between November 3rd and November 5th, yet also either managed to move the RAV4 off the... Well, on November 3rd, after Andrew Colborn shows up at Dolores' house and talks to Stephen Avery. Stephen then goes to Barb's house, informs them that the cops were there looking for Teresa, asks Bobby, Blaine, and them if they want to come to Menards. Now, Bobby says he has something to do. Question is this before Stephen cuts his hand open on the trailer or after? But anyways, planted the keys in the RAV4 and Avery's trailer unnoticed. November 3rd, November 5th, he had to either manage to move the RAV4 off the 40-acre property without the keys or drive it away and return it on foot from wherever it supposedly took it, and then sneaking into Avery's trailer again to hide the keys. At some other unidentified time, which, again, unnoticed. 6, found and then planted a tiny mangled bullet fragment that Bobby unexpectedly knew had the victim's DNA on it underneath items in the neighbor's garage. Or, alternatively, he shot the victim in Avery's garage on October 31st and then at another unidentified time scrubbed the scene with Avery remaining unaware. Despite Avery unsuitably having been working on his Suzuki and other vehicles in and around the garage around this time. Burned the victim's body in some undisclosed location and then moved the remains to Avery's burn pit. Again, completely undetected, and then it is so thoroughly as it included at least a fragment or more of almost every bone below the neck. An entire human skeleton along with the rivets from her jeans, nor has Avery provided any facts where convinced his younger brother Brendan to go along with his plan and fabricated confession implicating himself and Avery or why Brendan would do so. Even if one accepts the face value Avery's theory that Bobby was scientifically sophisticated and equipped enough for it to occur to him to do all of the blood evidence gathering and planting, Avery provides nothing that would explain why Bobby could have done so in a roughly half an hour window before the blood would have coagulated and dried when Avery was at Menards on November 3rd, and Avery has not planned even a single fact to establish how or when Bobby could have planted any of these rests of the mountain. Even Stephen Avery states that when he seen the lights by his trailer, he says it could have been Bobby. Because Bobby usually drove through that way. But, I don't know. In sum, Avery has provided no facts in this motion that would establish why Bobby would want to frame him or why, when, where, and how Bobby could have been even possibly accomplished any of these necessary tasks to make this theory plausible. He has supplied nothing other than series of constantly shifting affidavits about his and his other activities during the relevant time frame and then backfilled it with speculation with zero factual support and how a small fraction of the evidence against him, the blood in the car only, could have ended up where it was if someone else was the perpetrator and pretends the rest of the evidence does not exist. April 10, 2020 affidavit. This is flatly insufficient to provide facts that could show that Bobby had between the engineer a complicated scheme. Direct connection. Direct connection is assessed by considering the preferred evidence in conjunction with other evidence to determine whether, under the totality of the circumstances, the evidence suggests that a third-party perpetrator actually committed the crime, and take the defense theory beyond mere speculation. No bright lines can be drawn as to what constitutes a third-party direct connection to the crime, but it must be more than a connection between the third party and the crime. It requires some direct connection between the third party and the perpetration of the crime. Lewinsky's affidavits and then appropriately saw Bobby Dassey RAV4 on November 5th, several days after Mr. Halbach's murder, do not provide a link between Bobby Dassey and perpetration of the murder, and most generous exhibits Avery has submitted could establish that Bobby was involved in moving the RAV4 to the location where it was eventually found. There is nothing more than a possible connection between the third party and the crime. It provides no link at all between Bobby and the preparation of the actual killing. It also does nothing to establish that Avery was not the killer, Avery believed. Also, Lewinsky's evidence would show that perhaps Bobby was involved in trying to cover up Avery's crime. So, what do you guys think so far? I very rarely look at the chat, but I'm going to now. So, y'all got any questions before I continue reading? Yes, Carol, this is a response to Zellner's motion. This is not a decision. This has now Judge Flowers has to make her decision on what. We all know what she's going to do. She's going to deny it. And then Zellner's going to have to refile with the Court of Appeals. And then who knows? And T1, yes, I believe Scott Tadich was a cover-up for Mike Go. You got to take into consideration that it was Bobby Dassey that said that Scott Tadich would be able to verify that he's seen him driving. And Scott Tadich would know what time it was. And they don't talk to Scott Tadich to a long time. Way after Steve was arrested. End of November. After all, Avery recruited Brennan to help him try to cover up his tracks. The same could be true about Bobby. Nothing Sawinski avers connects Bobby to the actual killing in any way. Direct connection requires a slowing that under the totality of the circumstances, the evidence suggests that the third-party perpetrator actually committed the crime. Avery's multiple layers of conjecture piled on top of the allegation that Sawinski maybe saw Bobby push in a car similar to the victim's at some point do nothing to establish any factors showing that Bobby actually murdered the victim. In short, Avery's claim that any requirements are not satisfied is wrong. The tendency that Bobby committed this crime, based on what Avery has presented here, has not even entered the ballpark of legitimate. Avery's allegations are conjecture of the speculation plugged into unaccounted for periods of Bobby's time, the insufficient meat Denny, the dearth of facts in Avery's motion necessary to establish Bobby's motive or opportunity to commit this crime and then carry on an elaborate planting scheme, along with nothing trying Bobby to participate in the actual killing, means Avery has failed to establish a legitimate tendency that Bobby was the killer. Avery thus failed to meet the pleading burden of both the newly discovered evidence and his party claim. No hearing is necessary. Avery's newly discovered evidence claims multi-layered to be entitled to a hearing. Avery had to plead sufficient facts to establish not only that Sawinski's alleged testimony would have allowed him to meet the Denny test, which is explained above, he did not do, but also sufficient facts to establish that he had presented the third-party perpetrator defense. At trial, a jury would have had reasonable doubt about his guilt, and he's not done so. They're making an assumption on what the jury would have did, so they can't do that. Defendants must meet 5 per test to obtain new trial based on newly discovered evidence. To set aside a judgment of conviction based on newly discovered evidence, evidence must sufficient establish the defendant's conviction resulted in a manifest injustice. When moving for a new trial based on the allegation of newly discovered evidence, the defendant must prove by clear and convincing evidence that the evidence was discovered after the conviction. It was. The defendant was not negligent in seeking the evidence. Well, he wasn't. The evidence is material is to an issue in the case, and the evidence is not merely cumulative. If the defendant is able to make this showing, then the circuit court must determine whether a responsible probability exists and a different result will be reached in the trial. A court reviewing the newly discovered evidence should consider whether a jury would find that the evidence had sufficient impact on the evidence presented at trial that the jury would have reasonably doubt the defendant's guilt. While the court must consider the new evidence as well as the evidence presented at trial, the court has not based its decision solely on the credibility of newly discovered evidence. Instead, the court must ask whether a jury presented with this evidence, regardless of its lack of credibility, would have had a reasonable doubt about the defendant's guilt when it considered along with the evidence presented against the defendant at trial. The state disputes with the evidence of Avery submitted to material from the reason explained above, even if Avery could have met the first 4 prongs of the newly discovered evidence test, though he cannot show that this evidence would have caused the jury to have a reasonable doubt about his guilt. Because Avery failed to plead facts that would have sufficiently established the three prongs of Denny, his allegations that Bobby was the perpetrator would be inadmissible at the new trial. If the newly discovered evidence is presented by a defendant would be inadmissible at a new trial, there's no way it could have impact on the jury's evaluation of other evidence, and defendants fails to meet these burden. Lori Bembenek, run, Bambi, run. I just cited Lori Bembenek's case. And she was framed too by the Milwaukee Police Department. Her husband, Alfred Schultz, killed his ex-wife, and they framed her for it. As Wilson makes clear, the Denny test and the three-pronged test never becomes a one- or two-pronged test. If a defendant fails to make an adequate showing that any of these three prongs, the third-party preparatory evidence is inadmissible, and the state explained, Avery failed to meet us on burden of all three prongs of this test, but even determining on motive, his opportunity of evidence is flatly insufficient. Established that Bobby could have committed the crime or staged the crime scene as a directed connection. Evidence doesn't establish a connection between Bobby and the actual killing. According to no jury would have ever been pursued with Avery to establish. There's no possibility that it could have affected the outcome of a new trial. Even if the evidence were admitted and the theory of defense were presented, there's no reasonable probability of a different result in a new trial. Even assuming that there was sufficient to meet Denny and Avery had a new trial presenting his defense instead of the police bias defense, there is no possibility that any jury hearing it would have reasonable doubt about Avery's guilt. As explained above, there are far too many irreconcilable inconsistencies between Avery's allegations and Bobby Dassey and the actual evidence produced in a trial. Particularly damning would be Avery's complete failure to account for his DNA on the hood latch of the RAV4 and Ms. Hallbach's remains, again including a fragment from virtually every bone in a human body being found in his burn pit, and nothing to explain how Bobby could possibly be responsible for the bullet with Ms. Hallbach's DNA on it being found in the garage and matched to the gun above his bed. Avery's new defense would essentially be asking the jury to ignore the forensic evidence introduced against him, presented with the common sense explanation that evidence was located where it was because Avery shot and killed the victim and attempted to hide the evidence of the crime, versus Avery's attempt to paint Bobby in a porn, obsessed, scientifically savvy, extremely stealthy criminal mastermind who inexplicably wanted to frame his uncle. No one would have reasonable doubt about Avery's guilt. Courts may presumably find in a matter of law there's no reasonable jury could determine that the third party perpetrated crime in the light of the overwhelming evidence that is he or she did not. Overwhelming evidence that Bobby did not commit this crime exists in the utter absence of any facts trying to him to the actual killing or to even a single piece of forensic evidence. Every theory requires so many speculative leaps, ignoring the actual facts of the case. Reasonable moviegoers would be hard-pressed to sit through it. Any reasonable juror being asked to search for the truth in a murder trial would reject it without fail. Avery has failed to plead sufficient facts to establish a violation of Brady, when the record consistently proves that he could not do so. Avery failed to provide sufficient facts to establish that the audio clips materially. Under the 14th Amendment, suppression by a prosecution of the evidence is favorable to the accused upon request to violate due process, where the evidence is material either to guilt or punishment, in respect of the good faith or bad faith in prosecution. The evidence must be favorable to the accused, either because it is exculpatory or impeaching. It must have been suppressed by the state, either willfully or inadvertently, and it must be material to the defendant's guilt or punishment. Evidence is material that therefore must be disclosed only if there is reasonable probability that had evidence been disclosed to the defense, the result of the proceeding would have been different. I believe it would have been. Alright, a reasonable probability, the probability sufficient to undermine confidence in the outcome. However, showing that the prosecution knew of an item of favorable evidence unknown to the defense does not amount to the Brady violation without more. Defendant's request of Brady violation does not require a prosecutor the way through all government files and search for potentially auxiliary evidence. Improperly for the issues raised here, Brady does not require the prosecution to disclose the evidence that is merely potentially exculpatory. Stated differently, the state is not constitutionally required to turn over the type of information that could form the basis for further investigation by defense. The court's differentiation between potentially useful evidence and auxiliary evidence required to be disclosed under Brady. Avery has again failed to meet his pleading burden because he does not submit anything that would establish an actual Brady claim. Even true, there are several glaring failures with Avery as presented. First, Avery's dodged instance that Bobby Dassey was the state's primary witness against Mr. Avery at his trial remains false, no matter how many times he repeats it. Bobby established only that Miss Halbach arrived at the Avery salvage yard on the day in question, and that he saw Miss Halbach walking toward Avery's trailer shortly before she disappeared. The state's 16 law enforcement witnesses and 12 forensic scientists who explained that the enormous amount of forensic evidence pointing directly to Avery as the killer were all far more material than Bobby, and Avery fails to explain how attempting to impeach Bobby with the purported evidence would have turned the tide at the trial. Second, Avery's submissions are insufficient to establish the facts as his claim. Avery has presented nothing more than an unauthenticated piece of paper in which some unidentified person apparently typed their interpretation of what was said on the audio clip at some identified time. Absent from what Avery submitted to this court is any copy of the audio clip, let alone any documentation about when it was received by the sheriff's office, who answered, who transcribed the clip, when they did so, when they were using it in reference, any timestamps. Well, Senglob is the one that took the call from Sawinski, and he didn't write a report or follow up on it, obviously. And we wouldn't even know about this audio if it wasn't for Remaker slipping up at pretrial. And no wonder why they cherry-picked and only gave him certain calls. But, yeah, that's a whole other story. Assuming that everything Avery submitted to be accurate, though it still has established that it is material evidence that was required to disclose the defense, there are really no details contained in the audio clip that would indicate that Sawinski had materially accepted information. Sawinski said nothing other than that he had something that he didn't know if it was good information or bad information about the girl who was missing from Hilbert. This is everything contained in the audio clip. Nothing in those few sentences could have conveniently been considered material. Yeah, but they transferred the call to Senglob, and we don't know what was said after that. That's the problem. And there's no report of him writing even taking this damn fucking call, so. Nothing in those few sentences could even convincingly be considered materially explosive evidence that the prosecution should have been on notice to turn over. Indeed, Avery actually does not attempt to argue that the contents of the phone call are immediately exculpatory or impeaching. What he argues is if the defense had been provided with a snippet of audio, they could have tracked down interviewed Sawinski 100 motherfucking percent. But they did. That does not make this phone call clip Brady material. It makes it an avenue of investigation that could have led anywhere, which is insufficient to establish that materially. This shit just pisses me off. And it's sufficiently absent from Attorney Brewing's for Attorney Strang's affidavits as any allegation that they would have pursued Avery's new Denny. They were denied that by the judge. You do sue at your own peril. Blah, 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 blah. Remember what fucking Fallon said? Sawinski knew information. They say only that they would have pursued the information that Sawinski called the Sheriff's Department diligently, would have made a specific request for further information about the substance of the call from Sergeant Senglob. There's no allegation that they would have attempted to present this factual theory that Bobby Dassey was somehow responsible for the murder, either at the pre-trial, Denny hearing, or the trial. If they had spoken to Sawinski, and it's easy to see why, no reasonable jury would have believed it. The police frame-up theory was a far more believable defense. Again, evidence is only material if there's a reasonable probability that it would have made a difference in the outcome of the trial. a defense that would not have been presented without the made difference in the outcome of the trial. Therefore, Avery's affidavit is insufficient to establish facts to support a Brady claim. So all of Avery established and argued is that he has been provided this phone call clip. He would have had information that could have, from the basis of further investigation by the defense. This is definitely insufficient state or Brady claim. Avery's Brady claim regarding Kevin Ramlow was previously litigated but also fails on the merits. Avery attempts to relitigate the Brady claim that Kevin Ramlow allegedly told law enforcement that he saw Miss Callbox RAV4 off the Avery property on November 3, 2005. By his own admission, he allegedly made the argument to this court in his motion for reconsideration in October 2017. On the grounds that Ramlow's information was newly discovered evidence of the Brady violation, he again relied on the part of his July 2008 supplemental motion alleging that the contents of the dash computer would have allowed him to establish Bobby as a Denny suspect. The court denied merit new claims Avery raised in his motion in reconsideration on grounds that new claims were not an appropriate reason to reconsider earlier decision. A matter once litigated may not be really litigated in a subsequent post-conviction proceeding, no matter how artfully the defendant may rephrase the issue. Avery already litigated this claim in 2017. He claimed that Ramlow's information was newly discovered, which it was, evidence 14 reconsideration of the court's October 2017 decision pursuant. The fact that this court did not immediately address it when denying his motion, reconsideration, and material and presented to the court previously under one particular legal theory, this court properly denied it, meaning Avery cannot really relitigate it now. An appellate court is not a performing bear required to dance each of the every tune played on appeal. Neither is the circuit court required to immediately address in detail claims that are improperly before it explains why they are improperly raised, which the court did in this prior decision. The court's failure to address the merits previously does not permit Avery to continuously raise it until the court does so. The record conclusively demonstrates that the Avery could not establish a Brady violation in the hearing, even if this claim were not previously litigated and would fail, because the record conclusively demonstrates that the Ramlow says in an affidavit about selling Sergeant Anna Colborn on November 4th that he saw the victim's RAV4 on the highway cannot possibly be true. Sergeant Colborn ended this shift on November 3rd, 2005 around 11 p.m. Yeah, he was supposed to get off at 8 though. That's the problem. Why did he stay an extra 3 hours? The affidavit Ramlow submitted unequivocally states that midday on November 4th was at the Senate station in Manitowoc County Sheriff's Department officer came into the station, whom he claims he told he'd seen the victim's car on December 2016 and recognized the officer who had talked to the Senate station that was Colborn. Well, little tidbit. Right after 1 o'clock on November 4th, the Sheriff's Department is calling Rabas towing. I have an idea why. And Paul Rabas is the Maribel fire chief / tow truck driver that removes the RAV4 from the property on the 5th. But Colborn was off work on November 4th, 2005, meaning he was supposed to be off the 4th, 5th, and 6th, and he got called in on the 5th for security to help at the checkpoint. As soon as he arrives at the checkpoint, what do? Oh, come to the command post. Goes to the command post, and then he's assigned to the team that goes in to search Stephen Avery's trailer. And right before that, they're asking if anybody has cameras and stuff, and he says, "Oh, I got that right in my car, conveniently." But we don't see any of them photos that he took. That Colborn actually went into the Senate station on November 4th. Ramlow, by his own admission, does not know Colborn personally. Ramlow had no idea who Colborn was until he saw him on TV in 2016, and conclusively nothing Ramlow states in the affidavit or his claim that Avery's motion can possibly have happened. Colburn would not have been identifiable as a Manitowoc County Sheriff's Officer while he was off duty and thus out of uniform in a gas station. Yeah, I don't believe that. So there is no way that Ramlow saw him come into the gas station, identified him as a sheriff officer, told him this, then the record thus conclusively demonstrates that the state did not suppress any information about Ramlow's tale because there was nothing to suppress. The evidence did not exist. Finally, Avery has once again failed to plead sufficient facts that this information from Ramlow could have been material. As explained above, Avery did not plead sufficient facts to satisfy the three prongs of Denny and alleged that the Bobby was plausibly perpetrator, and the jury would not have heard the theory, which is the only way they would have been any sort of context of information. Assuming that Ramlow's information standing alone would have been admissible, there's no reasonable probability of difference result in the trial. Ramlow seen a car similar to the victims on the side of the road between November 3rd and November 5th does nothing whatsoever to exonerate Avery. Avery himself could easily have driven it there. After all, the state had no way of knowing what Avery did with the evidence between October 31st and November 5th. At the best, Ramlow's evidence would have allowed the state to fill in its own gaps on how Avery kept the victim's car hidden between her disappearance and the car's discovery on November 5th. There is not a reasonable probability that the jury would have reached a different outcome if presented Ramlow's testimony. Circuit Court have no authority to grant a new trial in search of justice when the request is made. Avery's final request that the court grant him a new trial in the interest of jurisdiction pursuant. There is no need to belabor why Avery fails to meet the requirements for each relief, because the Wisconsin Supreme Court has repeatedly held that certain courts have no authority to grant new trials in the interest of justice in criminal cases pursuant. Nor can such claims raised in the Wisconsin statute motion because of neither jurisdiction nor constitutional interest of justice. Claims only can be considered by the circuit court if they are presented in a defendant 97402 motion on direct appeal. As there is not such motion, this court lacks authority to grant Avery any relief on this claim. Conclusion: Avery has not pledged sufficient facts to meet the three prongs of Denny, and the record conclusively disproves much of what he states, which means his Brady and newly discovered evidence claim could not prevail even if he established the facts alleged at the hearing, even if he had met his pleading burden through. What he submitted did not establish he could have met the newly discovered evidence of Brady test because he cannot show that there is a reasonable probability of different results in the trial. Jury Representative Swinsky's Ramlow's evidence. The court should deny Avery's motion without an evidentiary hearing, which is some motherfucking bullshit. And then we have the Swinsky email. Appeal from orders of the Circuit Court of Manitowoc County presented before Newbar Riley. This is just everything that's happened. I've already read this before on my trial on my channel, so I see no need to read the rest of that. But before I go, y'all got any questions? Yeah, I said every part of her body, pieces of bones, which is bullshit lie. Well, I don't know when the state is going to respond. When Angela Sukowicz, I guarantee she's going to deny it. Do you have contact to anyone who's selling it over to pass on any of you come with? Anything I find has been emailed to her directly. Well, KZ can't respond yet. It's got to go. This is them responding to the Judge Sikowitz, trying to persuade her to deny his motion for evidentiary hearing. So after Judge Sikowitz suck at this, Judge Flowers, I'm assuming she's going to deny it, and then Zellner's going to have to submit back to the Court of Appeals, and it's just a never-ending process, chess match, back and forth, back and forth. But yeah, see y'all next time.